Graduations between land and sea, recent developments and emerging clarity. Clive.
Thank you very much indeed, Bob. That's much appreciated. I'd also like to echo previous speakers by adding my thanks to the organizers, Diplomatic Academy of Vietnam, the Vietnam Lawyers Association, for their wonderful organization of this meeting and the kind invitation to come and speak here. It's very much appreciated. Now, the topic that we're kicking off the morning here, and for me it's an exciting topic. I'm glad to see you all here at 8 o'clock in the morning, bright and sharp, to engage with this critical issue of defining the legal regime of land features, and particularly the issue of what is land and where does the land end and the sea begin. What I should say in opening is that I was anticipating only a 12-minute spell before you. I understand from my chairman that I actually now have 15 minutes of fame, so I'm going to try and push that envelope. Now, we have a long-standing understanding that the land dominates the sea, and that is long established and well accepted. Sovereignty over land territory is therefore critical and a fundamental precursor to advancing claims to maritime jurisdiction offshore. Now, that gives rise to two seemingly quite straightforward questions. What is land, and where does the land end and the sea begin? And that's really, through this presentation, although the paper is relatively lengthy, I'd like to draw out one or two strands from the paper, and particularly some of the more recent developments with respect to these issues. Now, defining land, it seems self-evident what land actually is, and this issue has not excited much in the way of legal commentary. We can perhaps take some cues from the regime of islands, particularly Article 121, Paragraph 1, whereby an island is composed of a naturally formed area of land that is surrounded by water and above water at high tide. So there are two critical criteria there in terms of the land being naturally formed and also the tidal criteria being above water at high tide. Now, those issues are intimately linked to the issue of territorial sea baselines, which we'll move to in a moment. But there are some potential uncertainties over defining what land actually is. What do we mean by naturally formed? Well, clearly this eliminates the possibility of essentially building your own land, building your own islands in particular. Artificial islands have no capacity to generate claims to maritime jurisdiction other than a 500-meter breadth safety zone. That said, we have a long history of trying to protect the coastline, of constructing coastal engineering structures, particularly where the coastline is threatened by erosion, by recession towards the land. Our natural reaction tends to be to try and protect the coast. More than that, many countries have also sought to reclaim from the sea, to extend their land territory further seawards, expanding the area of land and pushing the edge of the land, the baseline from which zones of maritime jurisdiction are measured, further seaward. That has tended to be generally accepted as practice by states. With respect to discerning features, particularly insular features, whether they are naturally formed or not, this creates something of hazard and threat in the context of potential global sea level rise. If a feature is above water at high tide at this moment in time, and the occupying power seeks to reclaim around it and indeed elevate it, to build upon it and augment it vertically, and the sea level rises, how do we then discern between the naturally formed component of its height versus the man-made addition to its vertical elevation? The other uncertainty that can arise is above water at high tide. We'll deal with issues of vertical datum and tidal levels in a moment or two, but the issue of, does a feature need to be permanently above high tide or only predominantly above high tide? We've just had an extreme weather event in the last few days in the South China Sea. Accompanying that super typhoon has been a significant storm surge. One can anticipate that when we're looking at the South China Sea insular features, the vast majority of which exhibit very limited vertical elevation, that storm surge may well have led to many of those disputed features being overtopped by the ocean, by the seas, through that storm surge. Does that disqualify them from being considered as land? Or is it only that they need to be above high tide for the vast majority of the time, and under exceptional circumstances can be overwhelmed? I'm more sympathetic to that viewpoint, which was put forward by Peter Beazley way back in 1987. Peter Beazley is the former UK territorial waters officer, and as a hydrographer, his input on these issues is particularly valuable, I think. As to the question of where the land ends and the sea begins, again, there seems to be an obvious answer to this. Clearly, the land ends at the coast, and that's where the sea begins. And Prosper Weil, in looking at the question of the land dominating the sea, expresses it in this way, that the land does dominate the sea, and it does so through the intermediary of the coastal front. In international law of the sea terms, this land-sea interface is given expression through the concept of territorial sea baselines. We generally term them territorial sea baselines, but they are the baselines that are relevant to the measurement of the whole range of zones of maritime jurisdiction. Now, baselines are important because they define the extent, or they bound the edge of land territory. They also provide the starting line for measuring zones of maritime jurisdiction, and you can see on the graphic there a schematic of maritime jurisdictional zones, all of which are measured from the territorial sea baseline. The one complication there are the complex criteria with regard to the limits of the extended continental shelf beyond the 200-mile limit, but nonetheless, robust measurements, distance measurements from baselines are critically important also to the definition of the outer continental shelf limits. Now, the fundamental article here that is of relevance is Article 5 of the United Nations Convention on the Law of the Sea, which mentions that baselines under usual circumstances, normal baseline, will be the low water line along the coast as marked on large-scale charts officially recognized by the coastal state. Now, there are a variety of types, different types of baselines that are allowable within the Law of the Sea Convention, but all of them to some extent depend upon the location of the low water line consistent normal baselines. These are the default baselines that every state possesses in the absence of any other claim. But all the other types of baselines, strait baselines, bay closing lines, river closing lines, archipelagic baselines, all need to be tied back to the coastline to points on the normal baseline. So normal baselines are fundamental to all baseline claims. The question that arises from Article 5 is essentially which low water line? There are multiple low and indeed high water lines to choose from. If we look at the gradient of a coastline, and one can see how the different types of low and high water line are in evidence. The mention of charts in the context of Article 5 is instructive. This suggests nautical charts. The implication of this is that if one relies on nautical charts, one has to rely on the low water line defined by the chart maker. There is a general trend by chart-making authorities to use a particularly conservative or low water line. The choice of a vertical datum along the coastline that provides for a low zero line. This is primarily for the purpose of safety of navigation, but it also has the advantage from the point of view of coastal states that it tends to advance the low water line, the starting line for maritime claims, further down the beach, as it were. Similarly, there are multiple high water lines to choose from, and this has a knock-on impact, potentially, on the classification of insular features, whether a feature can be considered an island subject to Article 121 that is above high water, or is a low tide elevation, or is simply a subsurface feature. Now, the problematic issue in defining low and high water lines is that it's particularly a difficult task in the context of waters that are particularly shallow. That might seem self-evident. Certainly, shallow waters are problematic from the point of view of defining low water lines because it makes surveying activity particularly difficult. In the context where we have potential islands and cays, reefs, islets and rocks which are very, very close to the high water level, this also becomes a problematic issue, especially so where the tidal environment is complex. And all of those factors essentially describe the situation in the South China Sea, where we have a particularly complex tidal regime, which is not consistent spatially and also temporally. So there are different tidal levels across the space of the South China Sea. In some parts of the South China Sea, we have a tidal range of almost nil. In other parts of the South China Sea, we have a tidal range of up to 2 meters. And that can have a significant impact on how you classify the features that exist in the South China Sea. Added to that level of complexity is the issue that, of course, charts are only a snapshot in time. Coastlines are dynamic. They change over time. So there is potential for the low water lines to move, to migrate, and therefore the potential maritime zones that are measured from them also to shift and change. If we look at the change of the tides from mean sea level to low tide and higher up to high tide levels, however defined, that clearly has an impact on what features are above high tide and can be considered islands or rocks within the meaning of Article 121, what features are low tide elevations within the meaning of Article 13 of the Convention, and what features that fall entirely below the low water level and can be considered merely components of the seabed. In terms of low tide elevations, again, these are naturally formed areas of land. So again, there is no issue of building your own artificial low tide elevations, but they are features that are above water at low tide, but awash and covered at high tide. I refer here to my colleague Clive Simmons' terminology, where he terms low tide elevations parasitic base points. They do not have any capacity to generate maritime claims in their own right, but if they lie wholly or partially within the 12-mile limit of an above high tide feature or the mainland coastline, then they can be used as base points for generating claims to maritime jurisdiction. There is some uncertainty, though, that even though there is that phraseology there that low tide elevations are naturally formed areas of land, the International Court of Justice has professed uncertainty as to whether they really constitute territory that is capable of appropriation. And we can refer to the Qatar Bahrain decision and also the Pedra Branca case for dealing with issues of low tide elevations. In terms of their capacity to be used as base points, we can see here if we have a low water line defined along a mainland territory generating a 12-mile territorial sea, and a range of low tide elevations scattered offshore, then clearly elevations 1 and 2 are within, or wholly or partially within, the 12-mile limit. Therefore, they can be used as base points for generating maritime claims, whereas elevations 3 and 4, being beyond the 12-mile limit, have no capacity to be used as base points in generating the maritime claims. And finally, I will come to the recent developments and really highlight the Nicaragua-Colombia case, where some of these issues really came to the fore. In particular, I'd highlight how the ICJ treated the feature of Quietzueno, which is a large coral bank with 53 features lying on top of it, and there was a dispute as to what character of features these were. What tidal level should be applied, the fact that these features are composed of coral debris, and that they are very, very small, as well as only marginally above high tide level. The ICJ decision on this is that in terms of the tidal level, the ICJ really took a very conservative view. It decided that on the preferred tidal models of either side, Colombia and Nicaragua, a single feature was above high tide. So it took that feature to be an island subject to Article 121. In terms of composition, the fact that this feature is composed of coral debris was regarded as irrelevant. Similarly, in terms of the fact that it was very, very small, was also deemed to be irrelevant. So, unfortunately, there was no issue of whether this feature was indeed a rock, because both the parties never characterized it as anything other than a rock. And there you can see on the northern part of the slide, you can see Quietzueno, which generated a 12-mile territorial sea. The low tide elevations within that limit were also used as base points, and it was enclaved on behalf of Colombia within the Nicaraguan exclusive economic zone. Final slide, Mr. Chairman, is that certainly defining land features is crucial to then advancing claims to maritime jurisdiction. That is especially difficult to do in complex tidal environments and areas where there are low elevation features such as the South China Sea, and I think there is great scope for collaborative, cooperative, joint research to try and define what type of features we're truly dealing with here. And there is certainly, consequence of the Colombia-Nicaragua case, some signs of incremental progress towards the definition and understanding of Article 121, but there is still that uncertainty over discerning between what types of features are capable of 200-mile claims and which are mere rocks which are incapable of generating exclusive economic zone and continental shelf rights. Thank you very much.
Thank you very much, Clive. Our second speaker in this session is Professor ERIK Frans from Belgium. His long title for his presentation is The Interaction Between the Commission on the Limits of the Continental Shelf, or CLCS, and the Dispute Settlement Bodies in the Delineation and Delimitation of the Extended Continental Shelf. New Tendencies. ERIK?
Thank you, Mr. Chairman. Good morning, everybody. I would also like to start out by thanking the organizers for having invited me, and certainly for being so professional in the sense that I must admit I handed in my paper very late, but I see that you all have it on the table this morning, so thank you very much for having materialized this. Indeed, my title is rather long, and for that reason, the outline of my presentation today will be first by starting to explain a little bit of what the title really means. Then we'll have a look at the first maritime boundary delimitation of the International Tribunal of the Law of the Sea, ITLOS. We'll then try to frame it in a broader framework, see where it fits within the development of the law in this area, and then finally try to tie up some conclusions, and all this in 15 minutes. Codification of the law of the sea, it cannot be repeated enough, is a major success of the United Nations. The United Nations is always blamed for everything and nothing, of being not effective. With respect to the law of the sea, they have been extremely effective in the sense that they codified the law of the sea not only once but twice, which is totally uncommon in international law. They did it in 1958, and again they did it in 1982. Now, if we look at the two notions which needs clarification in the title, it is on the one hand delineation and on the other hand delimitation. Delineation has to do with the outer limit of the continental shelf. Delimitation, on the other hand, has to do with what do you do when your continental shelf abuts on the continental shelf of somebody else, either when the country is located next to you or opposite to you, and then you have to delimit. Now, the distinction between the two of them is important, and also the relationship, and that is what the paper today will try to clarify. And as you can see, they are covered by different articles of the Convention as well. It's interesting to see that these rules which are applicable to delineation and delimitation have evolved in the law of the sea if you compare the text of 1958 and the text of 1982. On the one hand, some of them are plain uncertain and others are complicated certain. What do I mean by that? If you look at the different rules and you try to put it in a little scheme, it turns up something like this. On the one hand, if you look at delineation, the 1958 Convention tells us that the continental shelf extends or reaches to 200 meters of depth, or, and it is where it gets very unclear, the exploitability. Why is it unclear? Because nobody knows whether it has to be determined by each coastal state independently, or whether it has to be determined by the one who is most technologically advanced, who then sets the standard for everybody else. If it wasn't clear, how could we solve it in 58? Well, there was not much to be found in the Convention because there was only an optional protocol. And since it's optional, not many countries did adhere to it. Today we have Article 76, which is very complicated, but at least is also very clear in where the continental shelf ends. And in order, because it's so complicated, they even established a new organ, and that is the Commission on the Limits on the Continental Shelf, which was already mentioned yesterday. Now, if we look at the 200 meters or exploitability criteria, I think it's clear that it's plain unclear, in the sense that my own country, Belgium, we adhere to all the conventions of 1958, except for the Continental Shelf Convention, because we thought that this was too unclear to become a party to. On the other hand, Article 76 is exactly the reverse. It's very detailed, it's very clear, but it's also very complicated. And it's sufficient to look at this flow chart, which tells you how to implement Article 76 to grasp the difficulties which normally countries are faced with when they are trying to apply it in practice. And that's why we have this new body, which is the Commission on the Limits of the Continental Shelf. If we then look at delimitation, we have a totally different picture, because there we started out by a rule which had a substantive indication of how you had to go about when you had to delimit your continental shelf. It was agreement, it was median line, unless there were special circumstances. Again, the only option that there was, if you didn't agree with your neighbors, was to go for the optional protocol, but if one of the parties did not adhere to the optional protocol, you were left in the cold. Today, we have what Travis called a decodification of this rule, because from a rule we don't have a rule anymore, a substantial rule, because the only thing the Convention now provides is that you have to go for an equitable solution. And I don't have to tell you that countries very often have a totally different interpretation of what is equitable. And that is why today we have in the Convention Part 15, with all the 4 institutions to which you can turn if you want to have a solution to your problem. So here it went the other way around. We had a rule on the one hand, and today we don't have a rule anymore. But on the other hand, we have now a set of institutions which are able to delimit. If, of course, no exceptions are made according to Article 278. Explanation of the title, again, it means that what are we dealing with today? It's a very small area of the law of the sea, namely the area where the continental shelf extends beyond the 200 nautical miles. It's not always the case, but if your continental shelf is not too deep, then you can make use of it. Where did I get my inspiration? Because at one of the other regional conferences here, I once wrote a paper on the area in order to see how the international community defends itself against the extension of the continental shelf of coastal states. And at that time, of course, there was not yet a decision, and that's why we now turned to this decision of ITLOS, because it gives new insights in how one has to deal with it. Mostly, the ITLOS, the International Tribunal of Law of the Sea, is to be mentioned because it's the first case, maritime delimitation case in 2012. Most of the time they're dealing with incidental procedures. Either they are prompt release of vessel and crew cases, or they are provisional measure cases. And it was already mentioned yesterday that the most recent one was just 1 week ago, last Wednesday, when before the tribunal they were pleading for provisional measures concerning the Arctic Sunrise, the Greenpeace ship in the Arctic. Important for us, I think, is if you look at this picture, the empty seats of Russia. The Russian Federation did not turn up to defend its case, and of course, if you compare it to the arbitration which many of you are interested in here, which is the China-Philippines arbitration, it's very interesting to see that Russia used the same kind of, the same kind of wording that China used for not appearing before the tribunal. But for us important now is the Bangladesh-Myanmar case of 2012. We did some writing on it, but of course today we're not the only ones anymore, because it's very nice to see that many people here in the room already wrote on the same issue, so they will be here to help me out if the questions become too difficult. So it's partly consolidation, and this is not of what is of interest to us here, because if you look at the normal delimitation of the maritime zones, EEZ, territorial sea, everything within 200 nautical miles continental shelf, there's not much new in the decision. But the new part is where it goes on the, or it decides on the continental shelf beyond 200 nautical miles. So again, if you look at the map, what we are interested here is what is this very small area on the map. It's the area beyond 200 nautical miles where the court made a ruling that they simply gave a direction, and that would be where the extended continental shelf, how the extended continental shelf between the two parties should be divided. Now, this was a very difficult case for the court, because the problem was that the Commission on the limits of the continental shelf had not previously made a recommendation. And why not? Because one of the parties, Bangladesh, had objected to the fact that there was a dispute, and it's sufficient that one of the parties states that there is a dispute, and then the Commission can no longer make a recommendation. So it means that they were stuck in the sense that there was no recommendation, and if there is no recommendation, the question was, can you then delimit? So if you cannot delineate, can you delimit anyway between the parties? And this was what the issue which was confronted. The parties had different ideas about this. Myanmar objected to it because they said the international community stands out in the cold. There's nobody there to protect it if the Commission has not had a view on it, and ITLOS needed to wait for the recommendation. The Bangladesh counter-argued that this is not true. Very often there are third parties which are, or which might be influenced by delimitation, and the court has in the past had found very interesting ways of making sure that these interests would not be put in jeopardy. And how did they do normally? By either giving only a direction, by not giving an ending point of your delimitation. So there are many ways in which you can treat this issue. And also the other argument of Bangladesh was that there was a circular argument. It was, if you cannot appear before the Commission on the Limits of the Continental Shelf, and you cannot have the recommendation, then you will never be able to delimit. So it means that you are in a circular roundabout, because the delimitation has to await the Commission on the Limits of the Continental Shelf, which it cannot make a decision because of one of the parties bars it from making that decision. The tribunal finally said that there was no difficulty with the fact that the rules of, or the rights of third parties would be, or could be, endangered, because they are able to deal with that. And finally also they said that the object and the purpose of the 1982 Convention was that parties should move along, and you cannot have stalemates in the Convention, and if they are there, the tribunal thought that they should be able to overcome them. And that's exactly what they did. As far as the entitlement is concerned, then Myanmar objected once again. They said no entitlement can be secured if there is no recommendation of the Commission. On the other hand, the Tribunal said this is certainly not the case, because the absence of an outer limit does not mean that you have not an entitlement. Very often the baselines are not certain, but nevertheless states have a territorial sea and also a territorial, an EZ and other maritime zones, as Clive just mentioned. Bangladesh then said, well, yes, maybe, but if you look at the area, you have two main rivers. There is a lot of debris which runs into the Bay of Bengal, and the rivers are located on our territory. So all the debris which is make out the sediments, they all belong to Bangladesh, so the whole Bay of Bengal should belong to Bangladesh. And this was based on geology. Well, again, the Myanmar argued that this is totally untrue. They said, no, you only have to apply Article 76, paragraph 4, and this has only to do with geomorphology, so not looking into the substance, but only at the substance itself, the disposition of it. And then finally the Tribunal made it clear that, as for it, the notion of the natural prolongation, which was introduced in 1969, the court said this is not a separate condition that you have to fulfill. If you fulfill Article 76, paragraph 4, that is sufficient. What then is the context of this, the broader context of this decision? Well, it is not that there was no decision before that, and that's why this decision is so special, because it runs into a certain extent, the practice which existed before. Because the tribunals and the ICJ had given mixed indications. In Saint-Pierre and Miquelon, which was an arbitration, the arbitral tribunal refused to look into the matter, because they followed Myanmar, saying that if there is no recommendation of the Commission, you cannot delimit between parties. And also they said, you are infringing the rights of the international community if we would do so. In the case of Barbados, Trinidad and Tobago, it was already a little bit more lenient, because here it was stated that the delimitation, and I quote, of a maritime boundary in relation to that part of the continental shelf extended beyond 200 nautical miles, they fell under its jurisdiction. Yet, in this case, the court stated, since there was no continental shelf beyond 200 nautical miles, they did not have to treat the issue. But at least they projected the possibility for a tribunal to do so. Guyana, Suriname, a year later, 2007, here the tribunal again said that they, in principle, would not object to it, but the parties did not ask them to do so. And since we have a rule of non ultra petita, it means that the tribunal can never do more than what is asked by the parties before it. And then we have finally the ICJ, Nicaragua versus Honduras, in 2007, 1 month later, and there we had a reverse position once again. The court stated clearly that if you do not have a recommendation, there is no delimitation to be done. So we were back at square one. And then we had the ITLO decision in order to make clear to you that it was a very brave decision in the sense that it added something to the existing case law. Conclusions, my last slide. What is the importance now of Bangladesh, Myanmar in the broader framework? Well, certainly it's innovative in the sense that the tribunal starts from what is called a teleological interpretation. It means that you have to try to fulfill the goals of the 1982 Convention, and the goal of the 1982 Convention is to try to help states settle their maritime issues. And how you do that is not by leaving something as it is without a solution. You try to find a solution and you try to interpret the Convention in order to provide that solution. Otherwise, they said, and it was a nice quote, I think, you open a juridical black hole into which all disputes concerning maritime boundary in the outer continental shelf would forever disappear. And this is something that the tribunal did not find opportune. Now, what is the precedential value of this decision? Here, I think we have to be rather careful, because courts and tribunals can sidestep the impasse because of created by the CLCS, but on the other hand, you have to be very careful that in this case, the court very much looked at the circumstances surrounding it. And what were the circumstances? One, it was that both parties before the decision was made, had submitted their continental shelf claim. So it meant that the tribunal was very well aware that both parties thought that there was an extended continental shelf in the area. Secondly, the Bay of Bengal is also very exceptional in the sense that there is sufficient scientific evidence to prove that this is an extended continental shelf. So again, the court had no difficulty overstepping that as well. There is one later case, and this is interesting, of the ICJ, which had an opportunity to look at the decision of the tribunal. And this was Nicaragua versus Colombia, which was just discussed by CLIVE. Also with respect to the area beyond 200 nautical miles, the court made a decision. And it was interesting to see that even though they did not think that it was opportune to delimit, or delineate better, the outer continental shelf, nevertheless they referred back to the ITLO's decision, in which it was stated that it was possible. The court simply distinguished, because in this case there was only one of the parties which had submitted information to the Commission, and the information submitted was only it was not their final submission, but it was only a provisional submission. So it was only something very limited, from which the court could not make sure that there was no dispute as to the existence of an extended continental shelf. And with this, I would like to conclude my presentation. Thank you.
Thank you very much, ERIK. Third speaker is Dr. J. Patong from the University of Philippines, talking on the extended continental shelf in the South China Sea, delimitation, prospects, and challenges.
Thank you. Good morning, ladies and gentlemen. This is a purely academic exercise, although it's based on practice. The question that prompted this presentation is, there are three questions that prompted this presentation. What if the 9 dashed lines did not exist? What if none of the islands in the South China Sea mattered in delimitation? And what if everyone just applied UNCLOS? Because these seem to be the underlying themes in many of the solutions that are being offered for the South China Sea issues. So that is why we now have a presentation. Well, you have extended continental shelves in the South China Sea. What are the delimitation prospects and challenges which would appear in case all of those conditions were not present? Prospects in the South China Sea for the ECS are really signified by the fact that Vietnam and Malaysia made claims before the CLCS for extended continental shelf. These claims implicitly disregard the Spratlys and the Paracels in the submissions to the CLCS. And you see on the screen the areas that are subject to the submission. The Philippines, on the other hand, while it has not made a submission, takes positions in the arbitration case which are consistent with the idea that the islands in the South China Sea do not generate the full maritime zones and are only entitled to territorial sea enclaves. So they implicitly do not accord any 200 miles to any island, to any feature within its own Calayan Island group or within the Spratlys. Brunei, on the other hand, submitted the preliminary information to the CLCS for an ECS, although it is a little bit lacking in detail. That evinces its intention to apply for its intention and understanding that it is entitled to an ECS in that area. China, on the other hand, has asserted full 200-mile EEZ and continental shelf areas for the Spratlys, and this is contained in its note verbals of 2009 and 2011. It is silent, however, about the Paracels. However, despite this position, as you have seen in the cases that were illustrated by previous speakers, international law is trending against this position that any of the islands will be entitled to a full 200-mile EEZ and continental shelf. It should therefore be borne in mind that ECS in South China Sea is possible only if none, absolutely none of the islands in the South China Sea, save for Hainan, will generate 200 miles. If any one of them do, as you see from the illustration, the 200 miles projected from any one of them can erase any possibility of an ECS. Now, we've had some presentations already on the continental shelf. For those who are not familiar with the technicalities by the Article 76, this is the bare bones of it. What you need in order to have an extended continental shelf is to apply Article 76, where a continental shelf is considered to be the natural prolongation of land territory to the outer edge of the continental margin, or to 200 miles where the continental margin is less than 200 miles. This includes the geographic shelf, slope, and rise, and excludes the deep ocean floor. For illustration purposes, you just need to refer to this drawing where you have the shelf, the slope, and the rise. If your 200-mile limit is somewhere here in this, is somewhere before the rise, then you can claim an extended continental shelf. However, if the 200-mile limit is located beyond the rise, then you do not have an extended continental shelf, and you can claim only a 200-mile continental shelf. If you do have an ECS, this shall not extend beyond four lines, which will be traced by the formula in Article 76, paragraph 4, 5, and 6. So this is known in shorthand as the FOS, or foot of slope point, plus 1/3% sediment thickness line, the FOS plus 60 nautical miles, the 350-mile constraint line, and the 2,500-meter isobath plus 100-meter constraint line. To illustrate to you, the FOS plus 1% sediment thickness line is you need geological information to determine, number one, where is the foot of slope point, the point of maximum change in gradient of the continental slope. Determine the thickness of the sediments underneath that foot of slope point. Look for another point further out where the thickness of the sediment is only 1% of the thickness at the foot of slope point. No? And then use that as the outer limit of your ECS. Now, if it is the simpler formula of FOS plus 60 nautical miles, simply find the foot of slope and then measure 60 nautical miles, and that will be your outer limit. Once you have delineated that, and you can mix and match these two outer limits, these two formula lines, then you need to constrain it. You need to cut it down because there are certain limits. You cannot extend this indefinitely. And the constraints that are in Article 76 are either the 350 nautical mile constraint line, meaning you cannot have an ECS beyond 350 nautical miles, no matter how extended your sediment thickness line, your sediments are, or how far your sediments go. Or you can measure a 2,500-meter isobath and use that contour to add 100 nautical miles, and that will now form the other outer limit. Whichever one is farther, that is the most that you can claim an ECS. And therefore, you need to cut down, if it goes beyond those lines, you need to cut down the ECS, and then that is what forms your outer limits. Now, there has been a lot of discussion on the continental shelf, and we just need to keep in mind that it is an entitlement that is ipso facto and ab initio, meaning you are entitled to it even if you don't do anything. The problem, of course, is determining its outer limit. The other thing we must bear in mind, there is an idea of unity. There is only one continental shelf, even though we refer to a 200-mile continental shelf and an ECS. Actually, it's only one integrated continental shelf. Now, Article 76 paragraph 1 has been described in Nicaragua versus Colombia as representing customary international law. And it is therefore binding on all states whether they are not their parties to UNCLOS. That means that the continental shelf extends up to 200 miles or up to the continental margin. However, the court did not make a declaration as to the rest of Article 76, such as from paragraph 2 to paragraph 6, which lays out those formula and constraint lines. So this raises some questions. How can you now have a continental margin? How can you be entitled to continental margin as part of customary international law, when the means for measuring where that continental margin exists is not yet part of customary international law? So there seems to be some issues that are still pending with respect to the status of the paragraphs of Article 76. Now, UNCLOS, of course, we've heard this before. There is a duty to cooperate, and Article 74 and 83 lay out certain rules, and this was explained in previous presentations. What I would like to call attention to is that in jurisprudence, there are actually quite a number of principles that apply when you talk about delimitation. Aside from the equitable principles and relevant circumstances rules, you also have other principles, which I explain a little bit more in my paper. But these are things like optimal entitlement, non-encroachment, proportionality, non-advantage, no cut-off, seaward projections, and such. So there are actually quite a number of principles that you need to consider. There is this idea of a single maritime boundary, especially in the recent cases that touch on the extended continental shelf. In the case of Barbados versus Trinidad and Tobago, the idea of unity of the continental shelf was particularly emphasized. And based on that unity, the jurisdiction of the arbitral tribunal extended to the extended continental shelf. even though initially what was raised by the parties was only the continental shelf within 200 miles. In Bangladesh versus Myanmar, jurisdiction over the ECS was deemed to be necessarily, was exercised because it was necessary, especially in cases where there is a dispute over the ECS. And in the Nicaragua versus Colombia, what is interesting to note is that the court did not exercise that jurisdiction, but that was because there was apparently an absence of at least substantial information that could support the idea that could support an ECS claim. So that is probably why Nicaragua now has gone back to the ICJ saying that it now has more information and would wish the court to revisit the delimitation of the ECS. Now, so in South China Sea, how do we undertake this exercise? As I mentioned, we take the assumptions that there are no 9-dash lines, there are no small islands that will affect the ECS lines, and everyone makes a conservative UNCLOS claim. And we can use actually existing software that is available to everyone, and here I just use Google Earth with the existing data there. It is not sufficient, this Google Earth is not sufficient for a submission to the CLCS. However, it is sufficient for making certain plausible assumptions about possible delimitation issues. And you see there, what we are looking for is basically a natural prolongation based on the bathymetric profiles that you extend from the land territory up to 300 nautical miles or up to the extent where you can have an ECS. So this is an example. At the bottom there, that is the bathymetric profile of one of the lines extending from the coast of Vietnam into the South China Sea, and it actually coincides with the claim area in the northern claim area of Vietnam. So with that idea, let's look at the possible entitlements that can be seen. One, Vietnam and Malaysia, as I started this off, they have already made the claims to the continental shelf in this area, the one in the north area, and then the joint area down to the south. In the north area, there is a plausible natural prolongation, as you see from the bathymetric profile. And then in the joint area, both Vietnam and Malaysia have similarly made plausible, or there are plausible indications of a natural prolongation from their respective coastline. Vietnam and Malaysia made claims, but two other claimants which have not yet made any submissions are there is also evidence of possible entitlements in that area. So Philippines and China, and here I also consider Chinese Taipei, which has been acting rather separately with respect to the Law of the Sea Convention. Now for the Philippines, there is a clear indication of a natural prolongation extending from Palawan outwards or westwards into the South China Sea. And that is one reason why I believe that it is possible that the Philippines will can make a claim for an extended continental shelf in this area. It does have some issues, however, further up north from Luzon because the bathymetric profile will show a discontinuity, which you see there as a sharp break from the coastline, and then the rest is very flat, and that is basically your deep ocean floor. Now, of course, there is already some precedents in the CLCS's recommendations which indicate that it is possible that there is a natural prolongation even though there is a trench like that break that you see on the right side of that profile. But this depends now on better data. With respect to China, it is possible for China to make an ECS claim extending from, say, Hainan, and you see there that the prolongation is very clear, heading towards Macashiel Bank. And the bank itself is on that prolongation. You see that like pillar-like structure there to the right side of the middle part of that profile. And then when I consider Taiwan, the thing with Taiwan is that there is a particular challenge there in that its extension, any natural prolongation is in effect overwhelmed or cut off by a natural prolongation extending from the mainland. So this raises some very interesting questions if there would be separate considerations of ECS claims from these areas. As for Brunei and Indonesia, Brunei has submitted the preliminary information to the CLCS, and they are laying claim basically to an ECS, which is only possible if their continental shelf could extend outward to the maximum of 200 miles. And this means that it will reach into the joint area. The profile seems to support that possibility. As you see, despite the existence of the trough, the profile indicates a natural prolongation. Now, with respect to Indonesia, this is an interesting question because Indonesia has already delimited its continental shelf boundaries. But technically, if you were to draw a profile from Indonesia heading towards the South China Sea, it actually presents the classical natural prolongation shape, as you see there. It's a very, very smooth, very classical continental shelf area. So that raises some interesting legal possibilities. Taking this information together and using the 300-meter isobath as a proxy for a foot of slope, a region of the base of slope, which is possible because the base of slope of the Vietnamese and the Malaysian submissions seem to follow more or less this isobath. We can expect that this will be the possible configurations of additional ECS claims in the South China Sea. Those of China, Philippines, and then some issues about Brunei and Indonesia, which I will show to you. Now, these are the possible delimitation issues that are raised. There are delimitation issues now with respect to Philippines, China, and Taipei. Where will the maritime border be between these regions? Will China's ECS extend up to the Philippine 200-mile limit? Now, that is an interesting question because based on the natural prolongation arguments, it seems that it is possible that the ECS from the Chinese southern course can extend all the way to the 200-mile limit of the Philippines. Is Taipei's natural prolongation going to be short of 200 miles because it is cut off by the Chinese ECS? Now, is it possible for, say, if Pratas Island were to be given a full 200 miles, would it then be able to claim an ECS? The thing is, when you look at the profiles again, even from Pratas Islands, it seems that the prolongation stops very close to the land area. And then, of course, the basic question that this raises is how will Pratas Island affect the possible lines of delimitation in this region? With respect to Vietnam and China, the problem is how do you connect the terminal point of the Gulf of Tonkin boundary out to the full 350 nautical miles, because the idea seems to be that there should be a single maritime boundary. How will that how will those two dots be connected? What will be the treatment or the effect of the paracels through which the line will pass? Will they be enclaved? Will there be frontal projections or seaward projections or landward projections from these islands? Will Macclesfield Bank become a bone of contention? Will the two sides be competing over the area of Macclesfield Bank? And will a portion of the Chinese ECS be located beyond Vietnam's ECS, as you see from that corner in the lower right corner, where the possible outer limit can be located? In the case of Vietnam and the Philippines, there is at least a much more simpler delimitation issue because that white line that you see there is essentially what needs to be divided between the two. But the question that will be then raised will be what will be the effect, what will be the treatment of the Spratly Islands? Will this affect the location of the possible dividing line? And with respect to Vietnam, Malaysia, and the Philippines, this is probably the more complicated of these areas because the joint area, within the joint area, the northern portion of it actually could also be considered to be a natural prolongation extending from the Philippine landmass. So how is this area to be delimited between the three parties? What will be the treatment or the effect of the Spratly Islands again? And for the Philippines and Malaysia, probably the question that's right there in the closet is how will you deal with this issue considering the issues of Sabah? Now, with respect to Vietnam, Malaysia, and Brunei, Vietnam and Malaysia's joint area, actually Brunei, if it is true that it has an ECS, then the ECS will necessarily eat into or necessarily be carved out of the Malaysian side of that joint area, possibly at the very least. No? Now, how will, well, that first raises the question, how is Brunei going to reach 200 miles? Considering the configuration of the coast, the equidistant line will probably be much short of 200, but there is some conflicting information because there are some news that came out that there was already an agreement between Malaysia and Brunei, which allows Brunei access to the full 200 miles. I have not been able to confirm this either way because the information on the actual agreement really has not been released in public. But assuming that it can reach into that area, how will Brunei then be able to carve out a share of that joint Vietnam-Malaysian area? And how will this be affected by any one of the islands in this practice? Now, Vietnam, Malaysia, Indonesia. This is, as I mentioned, is an interesting problem because the Indonesian continental shelf was already previously delimited. But that previous delimitation was based on the 200-meter isobath under the 1958 Convention. Does this change? Does the fact that the UNCLOS has already entered into force introduce a new element into this? Will Indonesia still be able to claim a extended continental shelf or a continental shelf beyond 200 nautical miles? Can this be separated from the continental shelf that has already been delimited? So you're looking at various interesting legal questions. Would Indonesia even consider abrogating its previous continental shelf agreements in order to be able to lay a claim to a full continental shelf and ECS under UNCLOS? Now, so in conclusion, this desktop exercise really pursues the assumptions that have been made and the ideas that have been offered as to what could be the possible solutions in the South China Sea, with all the parties not giving effect to any of the islands and making conservative claims. But what it does really is to provide a kind of best-case reference scenario. Now, even an UNCLOS-based delimitation, therefore, presents some substantial challenges, and there is much cause still for competition and disputes, even without the current problems raised by the 9-dash line. The addition of the islands and their effects makes the scenarios even more challenging. Even if all the South China Sea claimants were to fully adhere to UNCLOS and then fully implement its provisions, protracted maritime disputes will still remain to be a possibility. And although UNCLOS points claimants in certain directions and can technically place them on equal footing under a rule law so that they all abide by the same rules, this will still not provide all the answers, and it even creates its own set of problems. Now, the final question that probably states should consider, given these possibilities, is that they really need to think carefully. Should they really pursue maritime delimitations, or should they think out of the box now and find other cooperative and creative solutions? I leave you with that. Thank you very much to the Diplomatic Academy of Vietnam for letting me be here, and thank you everyone for listening.
Can we go ahead, or is there a technical problem? Okay. The final presentations is a joint presentation by two members of the International Law Faculty from DAV. First speaker is Pham Long Dung. She'll be followed by Nguyen Ngoc Lam.
Thank you, Chair, for the introduction, and thank you, organizers, for giving me this opportunity to speak on this workshop. The Philippine-China arbitration is a topic of our presentation, and luckily, many speakers in previous sessions touched upon various aspects of this case, which means that our job will reduce significantly. I remember last year workshop in Ho Chi Minh City. On the second day, the ICJ delivered a judgment on the Nicaragua-Colombia case, and no one at that moment could even imagine that one day a case between countries in South China Sea could have brought before an international proceeding. And we are here today discussing a case between the Philippines and China, which is, from our perspective, is a great progress in promoting the effectiveness of the dispute settlement mechanism under UNCLOS. By saying that, I don't mean that the outcome of the tribunal would be ideal, since it is usually that no one party can get its all under any international proceeding. But the fact that one country is successful in bringing a case before an international tribunal itself is positive. We know that the case initiated by the Philippines and rejected by China, the 5 arbiters were nominated and appointed, and the tribunal met and established the rule of procedures, the deadline, and the Philippines was asked to submit its memorial, including both admissibility, the jurisdiction of the tribunal, and the merits of the case. And we therefore follow the same line in our paper, looking at both procedural and substantive aspects of the case. In the Philippine Statement of Claims, there are 13 points grouped in under 3 main questions. In our paper, we will group these 13 points to 5 groups, namely the China's U-shaped line, submerged features, features that are rocks, the illegal exploitation of resources, and interference of rights, including freedom of navigation. Looking at the Philippine claims, some remarks may be made. First, it has to be admitted that the Philippines tries their best to formulate their claim in the way that avoid to touch upon rights and interests of third parties. However, given the fact that the scope of the claim relates to many issues, especially the U-shaped line, which is crucial to the South China Sea dispute, it is very likely that any outcome may have some effect on third parties. Second, the Philippines stated that it is well conscious that China made a declaration in 2006. However, Philippines emphasizes that it doesn't aim to ask for determination of sovereignty or maritime delimitation. However, the question is that it is very difficult to differentiate whether to define whether a dispute is sovereignty or delimitation dispute or a dispute related to the interpretation of the convention. And the third point is that the Philippines emphasizes very much on UNCLOS in its claims and doesn't refer to international law in general. So the question is whether there is much difference between international law in general and the law of the sea, and if there is any difference, would it be so significant that it could hamper the legitimate rights of the member states of UNCLOS? In order for a case to be considered by arbitration under Annex 7, the case has to, the obligations to exchange views provided for in Article 283 has to be satisfied. And then the scope of the claim should not be those exceptions provided for under Article 298. China rejects to the jurisdiction of the arbitration and refer to the commitment to resolve their dispute by negotiation in DOC, even though the arbitration will not likely examine the content of the DOC. However, it should be noted that even though emphasizes the use of negotiation, the DOC itself by no means excludes the possibility of the use of other peaceful means, including arbitration, and the wording in the DOC shows it clearly. Even though China does not refer explicitly to the obligations to exchange views under Article 283, however, it can be inferred from their indications to the DOC that the requirement of exchange view is not satisfied. Since the Tribunal will likely to examine this issue in details, in our paper we have done some research on the jurisprudence related to the interpretation of obligation to exchange views. And in the Southern Bluefin Tuna case, the Tribunal found that the obligations to exchange views is met because the negotiation is prolonged, intense, and serious. In the other cases under ITLOS, it is found that the obligation to exchange views is met because there was a request from one party to the other party for information, and there was a failure to notify, and one party informed the permanent mission of the other party at the UN about the case. And the same approach in other cases under PCIJ and ICJ. Our conclusion is that the proceeding seems to provide loose interpretation towards this obligation to exchange views. And it is likely that the tribunal will find that, the test of obligation to exchange view is easily met. The question is whether the tribunal will request evidence of exchange of views related to any or to every of the 13 points stipulated in the statement of the Philippines, or to the whole case in general, or to the main questions. As the rejection of China is based on its declaration in 2006 and Article 298, we have examined this article and come to the conclusion that the two issues that the tribunal will likely find that it has jurisdiction is the issue of the alleged violation of the freedom of navigation and the issue of whether the features can be considered as rocks. The other three issues, namely the U-shaped line, submerged features, and alleged violation of the right of exploitation in EEZ and CS, the tribunal may have different approaches, and it is not quite clear how they will decide on this. The U-shaped line seems to be in the center of attention of everyone, and our view is that based on all the data available up to date, it can be concluded that the claim of the China based on U-shaped line is largely undefined and unformulated. It was first introduced internationally in a map attached to the note verbal in 2009 by China, and it contains no specific coordinates, and there has been no explanation towards the claim nor the legal basis of the claims. So our view is that it would be reasonable for the tribunal to hold its jurisdiction on the U-shaped line, or to hold its decision on the legality of the U-shaped line based on the fact that China has not fully formulated its claim. And would it be considered as negative or positive? From our point of view, there are some positiveness in this, since the tribunal refused to recognize the existence of the claim, which can be followed by states in the dispute when they negotiate over the disputed area, etc. This refusal or hold to deliver the decision until China clarifies its claim, but it is likely that China would not clarify its claim. And in addition to that, if the tribunal may add some statement in its judgment, so that to show that the party has to fulfill its rights and obligations in sharp compliance, in fully compliance with ANCORS, that may make some sense. The Philippines, however, has a slightly different approach on the U-shaped line. In its statement, it clarifies that the U-shaped line extends to as far as 870 nautical miles from the coast of China and to almost 50 nautical miles from the coast of the Philippines, which means that somehow the line is formulated vaguely. And if the tribunal takes this approach and do not pay attention to international law, focusing only on ANCORS as suggested by the Philippines, it may rule that China by no means is entitled to any maritime zones to the extent specified in the Philippines claim. And that would be somehow meet the expectation of many people. And in case if China clarifies its claim, then we also did some research, and since this was this was elaborated by many speakers yesterday. We will skip this part, and we just think that in case if the tribunal will look at the issues of the difference between historic title and historical rights, then the tribunal may find that it has jurisdiction over the issues, since the case here is historical rights and is not in the scope of the exception under Article 298. And on this, I would like to give the floor to my colleague, a very young and talented lecturer of the International Law faculty.
Thank you, Mrs. Ung, for the introduction. Before I begin, I would like to thank the organizers for the privilege to be here today. In my next part of the presentation, I will cover the rest of the 4 issues as we grouped from the beginning to try to see whether, to make sort of an informed guess as to whether the tribunal will find jurisdiction in this case. The second issue that we grouped was the question of submerged features. And in the claim of the Philippines made the claims that some of the features are within the Philippines continental shelf, and all of them are not within the continental shelf of China. Therefore, they are not entitled to occupy these features. We are using here a map by the courtesy of the U.S. government to show the position of some of these submerged features in the Spratly Islands. So we have here the submerged features inside the continental shelf of the Philippines, which the Philippines claims to be the Mischief Reef and the McKinnon Reef. And then we also have this, all of the submerged features outside the continental shelf of China. In the Philippines claim, it also brought up the issue of some features being only rocks under Article 121, paragraph 3 of the UNCLOS, therefore not entitled to an EEZ and a continental shelf, which I will address later on. Here, I'm also, it might be a bit small, but it might not be so sufficient to show, but this is just to illustrate. Concerning the submerged features not subject to occupation, case law has rather extensively talked about low tide elevations, not exactly submerged features, but it is our opinion that we can draw some sort of analogy from the considerations of the courts and tribunals with regards to low tide elevations and apply it to submerged features. And in the cases that this issue has been brought up, for example, in Catawba Rain or in the Malaysia, Singapore, or Nicaragua, Colombia, which is the most recent case, the ICJ has consistently emphasized that low tide elevations cannot be appropriated unless they are within 12 nautical mile of, which is in a territorial sea. So with that, with the cases before us like this, in order for the court to find jurisdiction to entertain the issue of the submerged features at the Philippines claim, we think that there are some issues that the tribunal has to consider. The first is that, are these features within the territorial sea of any of the islands in the South China Sea over which China claims sovereignty? Because if they are within the territorial sea of any of the islands, then according to the jurisprudence, China is allowed to occupy them. But then this begs the question of, first, whether China has sovereignty over the issue, which is sovereignty issues, which is of course excluded from the jurisdiction of the tribunal. And then it also entails the question of specifying the territorial sea of those islands, or the islands, or the EEZ, or the continental shelf of those islands, which entails the question of delimitation, and whether to see whether there's any overlapping of the territorial sea of those islands with any of the other islands over which the other claimants assert sovereignty over. Also, the Philippines claims that some of the features within the continental shelf of the Philippines and not in the continental shelf of China. The question is then for the tribunal to consider whether they are actually within the continental shelf of the Philippines and not in China. And for us, this looks like a question of delimitation, which is of course excluded under Article 298, paragraph 1A. And then the last question that comes to our mind when we read the statement of claims by the Philippines is that the Philippines says that Gavin Reef and Subi Reef are not Philippines says that Mischief and McKinnon are within their continental shelf, but they did not say that to Gavin and Subi, which sort of implies that these two features are not within the Philippines continental shelf. If they're not within the Philippines continental shelf, if they're not within China's continental shelf, then our question is, what standing does the Philippines have to bring these questions before the court? Some would argue that if they're not within anyone's continental shelf, they would belong to the area which under Article 136 is common heritage of mankind, which probably gives rise to actual popularis principle. But so far, this principle has met with a lot of criticism and difficulties in international courts and tribunals. So we think that the Philippines would probably have a very hard time arguing this before the tribunal. Concerning the second issue in my part, rocks not entitled to their own EEZ and continental shelf, we have to first notice that the type of dispute excluded under Article 298 is maritime delimitation dispute. Under Article 121, it is not a question of maritime delimitation, it's a question of maritime entitlement. Now the question is, are these different or the same? Well, to us it is different, which means that to us Article 121 would fall outside the exclusion of Article 298. But then there are other opinions that differ, because there have been opinions that if you isolate the question of maritime delimitation outside in the context of a maritime delimitation dispute, this would be salami slicing the dispute as put by Professor Alan Boyle. And if you just choose one part of the dispute as a whole to bring to the tribunal, you're actually trying to evade the consent of the other state, and this goes against the free choice of dispute settlement and the free choice of states' consent, as which is the underlying foundation for any international adjudication or arbitration. In order to respond to this argument, however, we have a few points. The first one is, in this particular case, no delimitation is requested. Therefore, for us, the question of, or the issue of isolation of issues or isolation of certain question within the whole issue is not of relevance. The second is that we refer to Article 288 of the UNCLOS, which says that any tribunal or any body under 287 would have jurisdiction over any dispute concerning the interpretation and application of the convention. So for us, to the extent that the issue are not included in 298 and to the extent that they concern the interpretation and application of the UNCLOS, then it can be brought before a body under 287, which in this case is Annex 7 Tribunal. Also, looking at the drafting history, the travaux préparatoires of the UNCLOS, it shows that the parties, the negotiators, the drafting parties intended to limit the exceptions under 298 to the minimum, and therefore states Article 298, as it stands today, show the will of the states. And so states can only exclude the three categories of dispute that are included in 298. And through the drafting of the UNCLOS, at no time was the legal regime of the island envisaged to be included into 9.8 in the negotiations. Therefore, for us, if we now include Article 121 into 9.8, this would disturb the very carefully struck balance by the drafters. So, looking at the things as a whole, it is our opinion that Article 121, the question of whether a feature is a rock or an island under 121, can be entertained by the tribunal. The fourth issue brought is the exploitation of resources, interference of rights, and including navigation. And for us, looking at Article 298 in conjunction with Article 297 under Section 3, we think that it is possible that the tribunal may be able to entertain the question of interference of freedom of navigation. Since I have very limited time left, I will go very quickly through this. Through our survey, we share the opinions of a lot of authors that so far international courts and tribunals have had the tendency to sidestep the issue of Article 121 whenever it is raised. And we can see that in the Black Sea case between Romania and Ukraine. We can see that again in Nicaragua, Colombia, when the court looked at the little features in this case. The question for us is, why is that so? Why do courts tend to avoid such issue? And for us, there can be several explanations for this. The first is that courts do not want to go what it's required to settle dispute in light of the principle of judicial economy. And Article 121 is also a very sensitive issue. It is not a coincident vagueness, it's a deliberate vagueness, and therefore courts do not want to put into the spotlight for sensitive issues. And then now courts are more reserved and cautious before, so though they don't want to venture into too much expensive international law interpretation. However, we believe, and we hope at least, that the tribunal in the Philippines-China arbitration will not follow suit and will look at this issue, since it is very crucial. It's very important not only to the two parties, but the claimants in the South China Sea, as well as to the development of international law in general. I think my time is up, so I will not go too much further because Professor Beckman might be very upset after that. So I hope that you can read the paper with more detail. So thank you very much.
Thank you very much. I'm simply acting under instructions to try to ensure we have time for discussion. Let me take the chair's prerogative and ask the first question, and that's to link the two presentations. We've had presentations on extended shelf claims in the South China Sea, and then on the case, and in particular the issue of the presence of the islands and what effect that would have on the extended shelf claims. Let me first say, my understanding of China's claim is they are claiming an extended shelf from the paracels. Their economic zone law says that they're claiming 200 miles from the baselines, and they've issued baselines around the paracels, and therefore one would assume they're claiming from the paracels, even though they have not, like other states in the region, shown the limit of their 200-mile zone. Their situation on Spratlys is slightly different because they have not issued any baselines around the Spratlys. So although the April 2011 statement says the Nansha Islands is entitled to economic zone, under Chinese law they have yet to claim an economic zone from those islands. But if one, and I think Jay said that they've made a full 200-mile zone. They have not in their statement. They've simply said the islands are entitled to an economic zone. But the question I have is, we have extended continental shelf claims, assuming China makes a claim, Brunei makes a claim, and Philippines makes a claim. We would then have economic zone claims from the islands. When there's an overlap between an economic zone claim and an extended continental shelf claim. Which one trumps, and do we have overlap? Because overlap is only under 83 between the continental shelves and under 74 between economic zones. So is this similar to the gray area in Bangladesh, Myanmar? If so, does the economic zone become fishing zone, or do we have overlap over rights to shelf? So we can try to tackle that one, and maybe ERIK can try to tackle that one as well. And CLIVE, okay, good.
Well, I only wanted to say that in the case that I've been discussing today, the Myanmar-Bangladesh case, the tribunal stated that with respect to the island in front of the coast, that if the island is competing with the mainland, there should be delimitation between them. But if the island's territorial sea is competing with an EEZ or a continental shelf, then that should prevail. So in answer to your question, I think this might be a direction in which it might be taken. Thank you.
Thank you, Bob. One thing you said there in the framing your question, I'm slightly confused by it, because I would have said that China does not need to claim a continental shelf because these are inherent rights. It has claimed an exclusive economic zone, albeit an ambit one without defining the limits of it, in common with many other states around the world, not just in the South China Sea context. And I would say that there is an EEZ continental shelf rights arising from its claim to the disputed islands in the south, in the Spratly group. Even though China has not indicated the location of its baselines, it has default normal baselines from its land territory. It hasn't defined which ones are capable, which features are capable of extended rights rather than mere territorial sea, which are islands versus rocks issue. But nonetheless, it has an ambit claim from normal baselines, would be the starting point, I think.
Oops. No. I would think that between the two, since the continental shelf has that ipso facto and ab initio status, unlike the EEZ, it is possible that there is a sense of the continental shelf trumping over the EEZ, and therefore the EEZ would only be, only a fishing zone. However, interesting, as I mentioned in the presentation, if any one of those islands were to generate the 200 miles, it might not even be necessary anymore to even claim an ECS, because the zones will overwhelm the area beyond 200 miles within the South China Sea. And if both Paracels and the Spratly Islands, for example, were to be entitled to a 200-mile zone, there's nothing left of that free area, I think.
I would like to add one point that even though it is not required that a state make a claim related to its continental shelf, however, it is necessary for them to make a claim related to extended continental shelf in this case.
Okay, let's open it to questions for the floor. Don Rothwell, then Mark, then Thong, and then... okay, we'll take 4 and then we'll let people respond. 5 is Hashim. Okay.
Thank you, Mr. Chair. I have a comment and 2 questions. My first comment relates to the paper by Ms. Pham and Ms. Nguyen. And that is that there might be some benefit in looking at the submissions made by Japan in the whaling case against Australia in relation to the question of jurisdiction, because in Japan's submissions they sought to collapse issues of delimitation and delineation of Australia's maritime zones in the Southern Ocean, with respect to Australia's declaration under Article 36 of the Statute of the International Court of Justice. So there might be some parallels between that and the way in which one can interpret Article 298 of the Law of the Sea Convention, and the ICJ's judgment on Japan's jurisdictional argument on that front will be interesting to see. My question in relation to your paper is that do you have a view as to what would the position be if the Annex 7 Arbitral Tribunal does take the view that it doesn't have jurisdiction because of China's Article 298 declaration, and what then would follow in terms of obligations with respect to Annex 5 conciliation, which is also applicable in the context of Article 298 declarations. My second question goes to either ERIK or Jay, and that is that, Jay, your presentation was very elegant, but it was based along lots of hypotheticals, so I'll sort of play along with the hypothetical. And so for ERIK and Jay, I'd be interested to see whether you have any views as to how an international tribunal or a court would view delimitation of a maritime boundary in the context of the way in which the court or tribunal would view continental East Asia against archipelagic Philippines. And so I'm particularly interested in, because if you look at Nicaragua, Colombia, of course a significant weighting is given to continental Latin America as opposed to the much smaller Colombian islands. Would a court or tribunal take that into account in terms of looking at the way in which the claims of archipelagic Philippines would be weighted in those circumstances? Thank you.
First, Mark, but I'd like to ask everyone with questions to try to keep their comments and questions as brief as possible so that we can get as many ideas as possible to the bench.
Thank you, Mr. Chairman. I have one question to Jay and one comment to Ms. Lan. Jay, I mean, in fact, Bob, you asked it in that direction. I mean, basically, am I correct then in interpreting you went a bit fast for me, that China could make a claim to extend the continental shelf both from its mainland, from Paracels, and from Taiwan as part of China, that would encompass most of the South China Sea? A yes or a no on that. Okay, Ms. Lan, you have an interesting interpretation of the DOC. Yes, it doesn't specifically exclude arbitration. It doesn't specifically exclude a lot of things. But there is a phrase there that would seem to obligate the parties to negotiate bilaterally. That was not there by accident. That was by intense negotiations late into the night, and China believes that it was accepted by its negotiating partners. So it's really not something that can be dismissed that lightly. I'm sorry, but you have to realize that. Yeah, thank you.
Thank you, Mr. Chair. Yeah, I try to keep my comments and questions very brief. One comment by way of question to Jay. Your presentation is very sophisticated, but I think that the problem with delimitation or extended continental shelf is not that complicated. It is only complicated because of the existence of the spratleys or the paracels in the South China Sea, and the question is, do they have continental shelf and exclusive economic zone? Otherwise, they have a territorial sea, and that will have take primacy over any extended continental shelf or even the normal continental shelf within 200 nautical miles. And then the second comment and question is, in delimitation of extended continental shelf, I think that it is very simple, because normally the coastline does not play any factor in the entitlement to extended continental shelf. And the question will be very simple, that you have to divide equally in order to ensure an equitable solution. So that is my view, and I would like to hear your view on that too. And the second comment and question is to Mrs. Lan Dung. Here I play the role of devil advocate, and let's see what is the purpose of the arbitration regarding some of the features in the spratleys. Do you think that it brings any meaningful result to the situation in the South China Sea? And then it will be should the tribunal consider that as an issue of admissibility? Thank you.
Stein.
I have first a pedantic question to ERIK Franks. When a state submits its calculation of the extension of the continental shelf outside of 200 nautical miles to the CLCS, does that represent in itself a claim, or is it just an intention of a claim, or is it just some technical help? And then I have just an objection to J. Batung Bakal. I think that your maps and all your displays of difficulties were quite impressive and thought-provoking, but I was disappointed with your conclusion that that this is so complex, so one should think out of the box and find some other cooperative solutions. I really think that the first task is to think inside the box and reduce the area that is complicated. And when you showed the map of the 200 nautical mile zones around the Spratlys and the Paracels and Scarborough Shoal, then this is completely unrealistic, because one can very easily see that it's the maximum extent of any possible claim or the maximum extent of an EEZ from those islands would be out to the equidistant line between it and the opposite coast of a mainland country. And that would already be very helpful, because it would reduce the area where China could exert its claimed sovereignty inside the U-shaped line. So that would be a matter of priority, perhaps most important for Vietnam, because Vietnam is further away from the Spratlys than Malaysia and the Philippines. Thank you.
Please keep it
Thank you
short.
very much. I have two very simple questions. First, is there any rocks that can sustain human habitation or economic life of their own? And what are the conditions for that, so that they can sustain human habitation? That's the first one. The second question is, how do we deal with the issue of human habitation? Do people have to live there? Or is the rocks or economic zone intended for the rocks or for the human habitation? Thank you.
Okay, thank you. We'll start with the youngest first and move this way.
Thank you for your question. I'll be addressing the first question with regards to whether if the Annex 7 Tribunal doesn't find jurisdiction, then Annex 5 conciliation will take place, and the significance, if I understand your question correctly. From my understanding, Article 2981A requires delimitation, conciliation under Annex 7 for only the first two types of dispute under 1A and not B and C. That's sovereignty issues and delimitation. But then it also says that sovereignty issues are excluded, further excluded from compulsory conciliation under Annex 5. So my view is that the question that is raised in this arbitration, as the Philippines is already clarified, is not a dispute of maritime delimitation. Whereas under 2981A, conciliation is for maritime delimitation should the tribunal doesn't find jurisdiction. In any case, however, conciliation, the recommendation of the Conciliation Commission is not binding. And then even if it does render a recommendation, it is really very dependent on the will of the two parties to actually see through to that recommendation. And frankly, in this case, the will for arbitration, which is compulsory, is not even there. So I doubt whether there's really the will to go through with conciliation, even if the Conciliation Commission renders the recommendation. So that would be my attempt to answer that question.
My question goes to Professor Mark-Valencia comment. And as I stated in my presentation, under paragraph 4 of the DOC, it reads that through friendly that the parties undertake to resolve their territorial disputes by peaceful means through friendly consultations and negotiation by sovereign states directly concerned, and everyone seems to stop at that. However, it follows in accordance with universally recognized principles of international law, and this part is here with intention too. This try to strike the balance between the need to negotiation and the necessity to follow the main principle of international law. And there is a basic principle of international law on peaceful settlement of dispute, which includes both many types of settlement of dispute, not excluding arbitration. And therefore, my point here is that, okay, there is an emphasis on negotiation. However, the parties to the DOC also mean that there are other available means. And besides, DOC is a political commitment, whereas the UN Charter, where the main principle of peaceful dispute settlement is a legal instrument, and it is difficult to agree that a political instrument can override a legal document. Thank you.
Very quickly, Robert. Ms. Lan, I understand that. What I really think you need to do is to talk to your negotiator who was there so that you can understand what was agreed.
Okay, I seem to have gotten most of the questions so far. With respect to the question as to how would the tribunal consider, say, the continent of East Asia vis-a-vis the archipelagic Philippines, I think that given the fact that the archipelago is essentially an archipelagic state, the whole point of negotiating Part 4 on archipelagic states was to sort of equalize the status between a continental state and a continental coastline vis-a-vis the archipelagic coastline or the combined coastline of the archipelago. So I would think that the tribunal would consider them on equal footing as coastlines, at the very least, especially in the selection of base points from which to measure any median line. They should, I think, consider the archipelagic configuration as equal in status as to the continental coastline. As to the question as to of the ECS from the mainland, oh, sorry, that's Mark. Yes, I just wanted to say, you're correct. If China were to claim the full zones, even just the 200-mile zones from any of or all of the islands within the South China Sea, it would essentially be able to take all of the seabed of the South China Sea, except maybe for a very small portion to the east of Luzon, adjacent to Scarborough Shoal. But then that is probably why, that's why I attach significance to the fact that they call Scarborough Shoal Wangyan Island, which seems to indicate that they also wish to extend 200 miles from even those rocks on Scarborough. This really emphasizes the effect, the full impact of according full zones to all of those islands. So the comment that the ECS is not complicated, that it is a simple delimitation issue, I would tend to disagree. Well, in the first place, when you talk about ECS having participated in the submission process, it's definitely not simple. The kind of scientific information and data and the way in which you pursue the claim is quite complicated, to say the least, because if you were to rely purely on, well, in our experience, if we had allowed the scientists to run away with the submission, it probably might not have been successful. So it was essential really to be very, very careful in making that submission. I agree that the Spratlys are what complicates the islands, but given the cases in Nicaragua versus Colombia, Nicaragua versus Honduras, I tend to not agree that I also think that even if the islands were to generate only the 12 nautical mile enclaves, it still poses some complications because of this idea of a single maritime boundary. Nicaragua versus Colombia is the prime example of that strange boundary around the islands that is laterally just extended eastwards. That, I think, is a kind of situation. That situation probably was not expected unless, sorry, it's not expected because it, in a way, some would argue that it's quite arbitrary, and it's actually more reflective of Saint-Pierre and Miquelon, which a lot of academics have nightmares about in terms of maritime delimitation. If the idea is to have a single maritime boundary extending from territorial sea, the 200-mile continental shelf, all the way to the extended continental shelf, the presence of those islands in between or straddling those boundaries at one point or another presents the complications. You might, for example, between the Gulf of Tonkin and the ECS of Viet Nam and China, how will that line wind around or through the paracels? That would be an interesting and contentious question. And it's not really a simple matter of dividing the ECS equally, I think, because as shown in the jurisprudence on the continental shelf, equity does not necessarily mean equality, and that was emphasized early on in the cases. What matters is proportionality, or a negative proportionality, as some have called it. As to Stein's objection, that the first thing is to think within the box. Well, I guess it's a matter of perspective whether you're in the box or outside the box. The point I wanted to raise was that it seems that in a lot of the discussions, you get this sense that the problem will be solved if none of the islands generate the 200 miles, if everybody implemented UNCLOS and simply applied its and simply measured zones from the mainland baselines. And what I tried to show is that even in that ideal world, that best case scenario, it's still a complicated area, and it can still generate its own set of disputes. Now the question that, the practical question really is, okay, it seems that now everybody wants to eliminate the 9-dash line so that we can move into an UNCLOS compliant configuration. If that happens, assuming that happens, what I'm looking at is that we're going to be spending another few decades again looking at how to delimit in accordance with UNCLOS each and every one of those areas. So, I don't know, I don't plan on living forever. So,
those decades are worth it.
And then as to the last question, to Pakashin's question as to the rocks, I think this is precisely what is in contention here because of the absence of guidance. But again, based on Nicaragua versus Colombia, it seems that we can at least be sure that anything that looks like Quitaseño is probably going to be just a mere rock, that regardless of human habitation or whatever. It's just going to have an enclave of 12 nautical miles. That being said, though, a 12 nautical mile enclave around a pile of guano is really an enormous, it's really still an enormous maritime area that should be important to all coastal states. Thank you.
Over time, so try to keep it brief.
Yes, trying to keep it brief and give a very brief answer to the questions. First of all, Don, whether the Philippines should have a special status when you compare it to a coastal state. I think it is more to do, or it has more to do with the way in which your islands are configured. When we're talking about the Philippines, I mean, it's a cluster of islands, it's a sovereign state. I don't see why it should be downgraded when there is some delimitation to be made from the Philippines. It's the same with islands, depending on where your islands lie. It has been mentioned, the Saint-Pierre-Miquelon, 1992. Canada very much tried to rely on the arbitration of 1977 in the Channel Islands to indicate that you should totally disqualify the islands and simply enclave them. But the tribunal very clearly stated, no, this is a totally different hypothesis, because in the French UK case, of course, you had the whole UK coast, which was there to level off with the French coast. So it depends on the configuration. I think that if you have a country like the Philippines, there is no reason why it should be downgraded in any way with respect to the delimitation. Then with respect to Stein, of course, as you know, if your extended continental shelf claim must be final and binding, you have to go through this process of submission to the Commission on the Limits on the Continental Shelf. So if a country does that, I think it has clearly an intention to claim an extended continental shelf. And then the last question of Hashim Dalal, this is a very interesting one because we have been making the distinction between rocks and islands. I don't think the distinction to be made is between rocks and islands. The distinction to be made is between islands and certain rocks, and on the other hand, certain rocks. So it means that within the rocks category you have two different ones. You have those who can have EEZs and those who cannot. And depending on in which category you belong, then you can claim the extended continent or the EEZ and the continental shelf. And the example that I would like to give is the Jan Mayen. Of course, Jan Mayen has been, as well in state practice as by judicial bodies, has been accepted as being something which can generate EEZ and continental shelf rights. And if you look at Jan Mayen, it's a rock, right? There is nothing there, you cannot grow anything. The people who are there, it's a weather station, people are flown in and flown out. So this is a good example of what you seem to indicate, that you have to be able to live there and cultivate your own things and live from the sea. Because there is even no ports, you cannot, with your boats, you cannot even land there. And this has been accepted by the international community apparently as something which can generate as well an EEZ as a continental shelf. Thank you.
Thank you very much, Bob. Very swiftly, I would engage with Don's question, hypothetical question regarding mainland coasts versus archipelagos. And I distinguish it two ways in terms of looking at baselines and in terms of coastal front. It's clear that international courts and tribunals have a tendency to choose their own base points rather than necessarily be bound by the claimed straight baselines of coastal states. And that has happened on multiple occasions. What we haven't had experience of is a court or tribunal dealing with archipelagic baselines. Now, Article 47 is, I think, rather more robustly drafted than Article 7. And both these archipelagic baselines of the Philippines and Indonesia fronting the South China Sea are compliant with Article 47. It remains to be seen how they would be treated in that kind of judicial context. But what I would say, if we're looking at the treatment of mainland versus islands, there has been a trend towards awarding the islands a reduced effect, partially on the basis of the differential in coastal front. Where we're dealing with the kind of archipelagic scenario of a compact archipelago, including large islands and an almost continuous coastal front of islands, I don't think the same kind of disparity will arise which would lead to that kind of shift. And on a final note for hopefully the session, I would say to Pa Hashim, in terms of the islands in the South China Sea versus rocks which are incapable of human habitation. I support Erik's viewpoint that rocks are a subcategory, disadvantaged as they are, of islands subject to Article 121. But I would say that my reading of the drafting history of Article 121, and you probably are in a better position than anyone else in the room to actually inform us of this, is that Article 121 is drafted in a deliberately ambiguous manner. So, yes, I would say there are probably small features that if the parties wish them to be granted a full 200-mile claim from those features, then yes, they are islands capable of that. But there is still great uncertainty in how to interpret and distinguish between different categories of feature. What there are in the South China Sea, though, are several larger features. Ituaba, Spratly Island itself, Thitu Island, for example, which are substantial, have vegetation, have structures built upon them. You could characterize them as islands capable of extended zones of jurisdiction, should you wish to do so. Their weight and role in maritime delimitation, however, is an entirely different question. Thank you.
I think we are overextended by about 5 minutes. Apologies to the organizers, but I think we've done quite a good job. I'd like to...
There's one question left unaddressed. Should we spend 3 minutes on that?
You can talk to the questioner during the break, I think, because we are under pressure to finish. So I'd like to join me in thanking our panel for a very good job.